The New York Attorney General Letitia James has refused to dismiss a $500 million civil fraud judgment against Donald Trump, despite efforts by his legal team. This comes as part of a larger ongoing legal battle involving Trump's financial dealings and behavior both during and after his presidency. Letitia James' decision represents a firm stance against Trump's attempts to minimize legal accountability, even as he faces mounting pressure from multiple investigations and court cases. Trump's legal team, led by John Sauer, recently sent a letter to Letitia James asking her to drop the $500 million judgment. The letter, sent shortly before Thanksgiving, leaned heavily on appeals to harmony, historical precedent, and national unity, even invoking the Thanksgiving Day Proclamation by Abraham Lincoln and a farewell address by George Washington. Sauer also referenced a Harvard speech by John F. Kennedy in which he called for unity. The central argument presented was that maintaining the judgment against Trump would disrupt national peace and prosperity, as well as undermine the principles of harmony. However, the letter notably lacked any legal basis or case law to support the request. Instead, it relied on moral and philosophical appeals, which James promptly dismissed in her response. The Attorney General's reply emphasized that the judgment was based on substantial evidence presented during an 11-week trial. This evidence demonstrated that Trump repeatedly misrepresented his financial condition to banks, insurers, and other entities for personal gain, thereby violating New York's fraud laws. James' response also highlighted the ongoing appellate process, which Trump himself initiated, arguing that the judgment should remain in place as it does not impair the presidency or national governance. James' office pointed out that civil litigation, even involving high-profile figures, does not impede government operations or the ability of an individual to hold office. This was reinforced by references to prior legal precedents, including the landmark case Clayton versus Jones, which established that sitting presidents are not immune from civil litigation for actions taken outside their official capacity. Sauer's letter was further criticized for its tone, with James' office noting his repeated self-references to his pending appointment as Solicitor General of the United States, a role he is expected to assume in February. This, James argued, was irrelevant to the merits of the case and only served to underline the hubris of Trump's legal team. Legal experts predict that the $500 million judgment, while significant, is unlikely to survive unscathed through the appellate process. New York's First Appellate Division is known for reducing large judgments, and Trump's legal team is expected to argue that the judgment should be substantially reduced, if not overturned entirely. However, even if the judgment is reduced, it is likely to remain in the hundreds of millions of dollars, representing a significant financial liability for Trump and his businesses. This is not the only legal setback Trump is facing in New York. Manhattan District Attorney Alvin Bragg has refused to vacate Trump's 34-count felony conviction related to falsifying business records. The DA's office submitted paperwork reinforcing their opposition to Trump's requests for leniency or dismissal. Trump's legal team had argued that the charges were politically motivated and should be dropped, but the Manhattan DA maintained that the evidence against Trump was overwhelming and unrelated to partisan concerns. In a broader context, Trump's legal challenges are piling up on multiple fronts. 4 federal judges recently upheld criminal convictions and sentencing for January 6 defendants, dismissing arguments that Trump's promises to pardon them should affect their cases. These decisions underscore the judiciary's unwillingness to allow Trump's political rhetoric to interfere with the rule of law. Meanwhile, Trump also faces several civil rights lawsuits, many of which involve allegations of misconduct during his presidency. These cases are being handled by a variety of federal judges, including Judge Amit Mehta, who has been presiding over some of the most high-profile cases stemming from the January 6th insurrection. These cases are expected to proceed well into 2024, ensuring that Trump's legal woes remain in the public eye for the foreseeable future. Adding to the mix is Trump's nomination of Harmeet Dillon to head the Civil Rights Division of the Department of Justice, a move that has drawn significant criticism from legal experts and civil rights advocates. Dylan's track record includes positions and legal arguments that are widely seen as hostile to voting rights, LGBTQ+ rights, and abortion access. Critics argue that her appointment would represent a major setback for civil rights enforcement in the United States. Dylan's nomination is emblematic of Trump's broader approach to governance, which prioritizes loyalty and ideological alignment over qualifications or commitment to public service. Her confirmation process is expected to be contentious, with Democrats and civil rights organizations mobilizing to oppose her appointment. In a recent interview with NBC's Kristen Welker, Trump further demonstrated his lack of understanding of key constitutional principles. When discussing birthright citizenship, a concept enshrined in the 14th Amendment, Trump made several inaccurate statements, revealing a fundamental misunderstanding of the Constitution. His remarks drew widespread criticism from legal scholars who emphasized the importance of upholding constitutional protections for all individuals born in the United States. Taken together, these developments paint a picture of a former president facing an unprecedented array of legal and political challenges. From civil fraud judgments and felony convictions to ongoing civil rights lawsuits and controversial appointments, Trump's post-presidency continues to be defined by legal battles and public scrutiny. As these cases progress, figures like Letitia James and Alvin Bragg are emerging as key players in holding Trump accountable, ensuring that no one, regardless of their status or position, is above the law. The recent legal developments surrounding Donald Trump's convictions in the Stormy Daniels hush money case continue to evolve, particularly with the latest maneuver by his legal team. This matter, which stems from allegations and actions preceding his presidency, has garnered significant attention as it delves into uncharted legal territories involving a former president. The Clayton motion and Trump's legal maneuvering. Donald Trump's legal team filed a motion to dismiss his conviction based on manifest injustice under New York's criminal procedure law, CPL, a provision that requires evaluating a series of factors, known as the Clayton factors. These factors assess whether overturning a conviction is justified based on fairness and justice. However, rather than addressing these 8 critical factors substantively, Trump's lawyers presented what the Manhattan District Attorney's Office described as a rehash of previous, unsubstantiated arguments. The Trump team's brief focused heavily on claims of bias, targeting the judge, his family, and even Michael Cohen, Trump's former attorney-turned-witness. They alleged that the conviction should be vacated due to perceived unfairness, but the Manhattan DA responded forcefully, pointing out the lack of any meaningful analysis of the Clayton factors in Trump's motion. The DA's 86-page response meticulously detailed why these claims hold no merit. Immunity arguments and their rejection. Trump's lawyers also argued for immunity, suggesting that he should be shielded from prosecution and sentencing because he is running for president again. However, the Manhattan DA's office countered that whatever immunity Trump may have held during his presidency does not extend to actions committed before he assumed office. Furthermore, the concept of president-elect immunity, an idea floated in Trump's filings, is non-existent in U.S. law. The DA's team further noted that even if Trump were to regain the presidency, any temporary immunity would not invalidate the conviction itself. They argued that the immunity Trump seeks is not a blanket shield but rather a delay in execution of penalties. In simpler terms, the DA stated that Trump could still be sentenced now, and the court could decide whether the sentence's enforcement would be postponed until after his potential presidential term. The DA's office made it clear that the conviction itself, secured through weeks of trial and significant evidence, must stand as a validation of the justice system. Evidence and violations of gag orders. The Manhattan DA's response included a detailed summary of the overwhelming evidence presented at trial, ranging from witness testimonies to documentary proof. This evidence underscored the strength of the case, which the DA argued directly contradicted claims of manifest injustice. Among the most notable witnesses were Michael Cohen and members of Trump's own organization, who corroborated the allegations. Additionally, The DA's filing highlighted Trump's repeated violations of gag orders imposed during the proceedings. The filing listed at least 9 separate instances where Trump publicly attacked judges, prosecutors, and their families. In some cases, his remarks were described as violent and threatening, such as a post showing Trump holding a baseball bat next to an image of Manhattan DA Alvin Bragg, an image widely condemned for its implications. The DA's office argued that these actions not only undermined the judicial process, but also illustrated Trump's disregard for legal boundaries, further invalidating his claims of manifest injustice. The abatement by death doctrine. One of the more unusual elements of the DA's argument was a reference to the abatement by death doctrine. This legal principle allows for the termination of proceedings when a defendant dies before sentencing. While Trump is obviously alive, the DA's office suggested a parallel. Trump's 4 years in office, if he were re-elected, could be treated as a period of legal suspension similar to death in procedural terms. The court could proceed with sentencing now, while enforcement could be delayed until the conclusion of Trump's potential presidency. This pragmatic approach avoids erasing the conviction while balancing the realities of a presidency. This argument became the subject of sensational headlines, with some media outlets misrepresenting the filing as the DA wishing for Trump's death. However, the comparison was purely procedural and intended to address potential delays caused by Trump's political status. Sentencing and likely outcomes. Judge Juan Merchan, presiding over the case, is expected to deny Trump's motion to dismiss the conviction based on immunity or claims of manifest injustice. The judge is likely to proceed with sentencing, following the Sixth Amendment's mandate for a speedy trial, which includes sentencing. Legal experts predict that Judge Merchan may sentence Trump while providing him an opportunity to appeal. Given Trump's candidacy for the presidency, enforcement of the sentence, such as incarceration, may be postponed until he leaves office. However, this does not erase the conviction or diminish its significance. The appellate courts in New York will likely affirm this approach, balancing public justice and constitutional considerations. Should Trump's legal team attempt to elevate the matter to the U.S. Supreme Court, it is improbable that the court would intervene, as this is fundamentally a state-level procedural issue. Broader implications. Trump's legal challenges extend far beyond the Stormy Daniels case. Federal judges continue to oversee trials and sentencing related to the January 6th Capitol riots, even as Trump publicly promises pardons for those convicted. This disconnect between Trump's rhetoric and the realities of the justice system underscores the ongoing legal reckoning for individuals tied to the events of January 6th. Meanwhile, Trump faces civil rights lawsuits under statutes such as the Ku Klux Klan Act, which hold individuals accountable for inciting violence or infringing on constitutional rights. The outcomes of these cases could further complicate Trump's legal landscape, particularly as he navigates his political ambitions. Civil rights and policy implications. In parallel, the Biden administration has nominated individuals like Harmeet Dillon to key positions, such as leading the Civil Rights Division of the Department of Justice. Critics argue that these appointments signal shifts in civil rights policy that could have long-term implications. Trump's rhetoric on issues like birthright citizenship further reflects his continued influence on political discourse, often misrepresenting or misunderstanding constitutional principles. Final thoughts. As the legal, political, and constitutional implications of Trump's cases unfold, they highlight the complexities of holding a former president accountable while preserving the integrity of democratic institutions. From state-level procedural arguments to federal civil rights challenges, the coming months will be pivotal in shaping the intersection of law and politics.